my motion was to temporarily suspend the hearings until we answered what I believe is a prejudicial question being raised by Justice Mendoza, until we determine and comply with the proper constitutional procedure. But the leader said, digesting what has been brought up so far, also through reviewing the records of the deliberations of the Constitutional Commission.
You acted as if you are revising the Constitution by changing the wording. The effect, I know, is to limit the nationality requirement to to basic education and allow foreign investments in higher education. But you're already doing what Congress should do later on. Just say, unless otherwise provided by law. So, just word it this way: educational institutions, etc., unless otherwise provided by law, shall be owned by Filipino citizens. Later on, Congress can pass a law saying that basic education is not, foreign investment is not allowed in basic education. That's how you do it. Don't change the wording of the law, except of the Constitution, except to add, unless otherwise provided by law. And then you can even put that in the title, a proposal to amend the restrictive economic provisions of the Constitution, Articles 12, 14, and 16, by adding the words, unless otherwise provided by law. Ganun lang. What is the effect? The effect, if approved by 3/4 of the Senate and 3/4 of the House, it becomes a proposal submittable to a plebiscite. And you submit it to the COMELEC for COMELEC to hold a plebiscite within that 60-day, 90-day formula. And if approved by the people in the plebiscite, then the amendment is carried. The provision in the Constitution is now amended to read, education, etc., shall be owned by Filipinos unless otherwise provided by law. So, it's still prohibited, but a law can be made to change it, to allow foreigners. That on ordinary law, that's no longer amending the Constitution. You are now allowed by the Constitution to amend the law. Is that irregular? Of course not. There is already a provision in the Constitution now that says that practice of profession shall be limited. Practice of the legal profession shall be limited to Filipino citizens except in cases provided by law. Nakalagay na ngayon yan sa Constitution, tingnan ninyo. So that formula is already in the Constitution, accepting. So there's nothing wrong in saying that advertising shall be limited to Filipino citizens except as may be provided by law or unless otherwise provided by law. It makes it changeable by legislation. That's all it does. Thank you, Madam President. Thank you, Mr.
Thank you. With your indulgence, Senate President Pro Tem, the Senate President wants to intervene.
Really quick on the ideas of course, Chief Justice Davide and Justice Cuna. We discussed it also very quickly on the side on the amendment of our rules. We had said that the committee may be allowed to do the committee hearings, get, of course, the advice and the inputs of different luminaries, whether in the legal field or the financial side, the financial sector, and all other sectors concerned. But at the end of the day, we were discussing with the majority leader what would trigger the creation of a Senate counterpart, Senate Constituent Assembly, was basically the submission of and you can add to our suggestions when we craft our rules, is the submission of the committee report by the committee signed by the majority of members, meaning it can be taken for plenary action. So that could be a signal. Once that is done, then we can come up with a Constituent Assembly on the Senate's part. We're actually thinking about the idea not to have it during plenary session at 3 o'clock, but earlier in the morning, so it'll be treated as a separate entity, a separate assembly, and we can discuss. And I think the minority floor leader agrees with me because we'll be part of the rules making when we come up with the final amendment to our rules. And then we could make the decision wherein the amendments can be voted upon individually. Let's say there's on issue on national patrimony, education, and all. It can be done 3/4 vote per amendment. And the reason why I say that is I foresee a problem in the future wherein the House may stick to its guns and add more. 7 amendments or even political amendments. And so definitely that is where I see a bit of a difficulty, because we're going to have to look into a bicameral setup wherein they will submit to us their version, an amended or the approved version of the House, and we will also submit our approved version, and eventually that will be up for discussion. How, I think that is what I foresee is going to be the problem there. How do we reconcile these two documents? Of course, if the Senate refuses to agree to the amendments of the House, then nothing is passed. In other words, we have no amendments to the Charter. So that is how we're going to craft our rules for the information of everyone, and that's the suggestion we made to the head of the Rules Committee, which we'll be discussing lengthily now with the Minority Floor Leader and the members of the Rules Committee. But more or less, that's acceptable, Your Honors. I presume that that is an acceptable proposal on the rules. So we will be meeting outside of plenary session, because this is not legislation. This is amendment to the Constitution. And how the rules will be done on approving each individual amendment will be discussed there, as long as it is 3/4 vote approved by each this Constituent Assembly, headed on the part of the Senate. So yun lamang po, Chairman, and I think actually that's exciting. We'll be discussing that in the Rules Committee. Will assist the Majority Floor Leader on crafting the specific rules on this particular topic on amendments to the Constitution. Thank you, Chairman.
Thank you very much, Mr. President, and back to you,
Mr. Chairman.
Senate President Pro Tem. Senator Nancy.
Just additional inputs dun sa sinabi po ng ating Senate President. Kailangan po bang simultaneous, if we call as a joint assembly, should the House counterpart file a similar rules, or dapat din pa silang mag-convene as an assembly?
They have their own rules of procedure. If that's my initial impression, of course, I could be
would that-
corrected by the.
Would that constitute a constitutional assembly when only one House declares an assembly?
But
Diba?
clearly we cannot pass any amendments if. But no, let's
Maybe we
let's
can,
address it to our resource persons.
ask for our
any of our resource
resource
persons. Can.
Mr. Chairman,
Pwede po bang one-sided?
Mr. Chairman, this problem has really been a vexing problem since the adoption of the 1987 Constitution, all because of an oversight. You see, the beginning of this problem was this. The Constitutional Commission, which drafted the Constitution, was working on the basis of a unicameral Congress, National Assembly, as it was called. At the very beginning, there was a debate whether the legislative department should be bicameral or legislative or unicameral. So this problem hung until the end of the session of the Constitutional Commission. With two houses, you have a problem. How are they going to meet? As you are now experiencing the problem. The chairman, if I recall, from my reading of the records of the commission, was the late Commissioner Suarez. The question was, what are we going to do? On what assumption are we going to work on? On the assumption that we will adopt a bicameral Congress or a unicameral National Assembly. This problem was not resolved until the very end. So, with that problem, it was agreed in the Committee on Constitutional Amendments and Transitory Provisions. It was agreed this way. Said Suarez, we will keep it like this until it is decided otherwise that it will be bicameral. In what way? He was talking with Commissioner Regalado. And what would it be? In the event that we adopt a bicameral Congress, we will insert the word joint assembly, the votes of the two houses counted separately. on that basis. So, all the provisions of the Constitution, the draft of the Constitution, based on a unicameral National Assembly, were put on suspensions. Then finally, Commissioner Rosales, the chairman of the executive department, said, we have agreed it will be a bicameral Congress. So all provisions of the constitutions were amended so as to reflect this. And so you have several provisions of the Constitution. For example, when the vote for president is counted, the two houses meet in a joint session to proclaim the president and the president-elect. When there is a vacancy in the office of the vice president during his term, the president is given the power to nominate, and his nomination of the vice president will have to be confirmed by the two houses in joint session, voting separately. All voting separately. Number three, when there is a problem, is the president disabled from performing his official duties, and his cabinet believes he's disabled, but the president insists that he's no longer disabled. Who resolves the problem? It is Congress in joint session again, voting separately. When martial law is declared, and the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus is suspended, who can revoke that? Congress. But how can Congress act? It is only here where Congress, although meeting again jointly, vote as a whole, but otherwise meeting jointly. In all of these instances, Congress is required to meet in a joint session, but the votes of the two houses are to be separately counted as a consequence of the decision of the executive department, to have an executive department committee changing these provisions. Now, Mr. Chairman, I should say, these are non-legislative functions of Congress. The main function is lawmaking. These are non-legislative functions. The amendment of the Constitution is not the work of Congress. It is also a non-legislative function. It is just as important as the declaration of war or a state of war, which requires Congress to meet jointly as one assembly and vote separately. If you regard the amendment of the Constitution as important as that, don't you think that this silence in Article 17 as to how Congress should act as a constituent assembly, would there be doubt in your mind that it is not Congress as a lawmaking body, but it wears a different hat, that of being a constituent assembly? And in two decisions of the Supreme Court, Tolentino versus Comelec, Gonzales versus Comelec, the Supreme Court said, when they act as an assembly, they do not act with any distinction whether they are senators or congressmen. They are as one assembly, members of a constituent assembly. Therefore, I submit, Mr. Chairman, that this body is not a constituent assembly, nor a part of a constituent assembly. Because to become a constituent assembly by resolution my opinion is that the two houses must first agree to sit together and then pass a resolution to constitute themselves into a constituent assembly. It is only from then that you have a constituent assembly contemplated in Article 17, Section 1, Paragraph 1. Otherwise, no. That's it. It was an oversight, and I think it behooves Congress. I've been raising this problem because many times I've been invited to testify before cha-cha committees, both houses of Congress. And in both instances, I've insisted on that. Otherwise, to say that they must vote separately, you are disregarding the fact that Congress is not acting as a legislative body. Congress is acting as a constituent assembly. Isa lamang assembleya, not Congress. Because when we speak of Congress, we speak with the two houses. We imply the House and the Senate. But when we speak of a constituent assembly, we call on the Congress to wear its other hat, that is, as a constituent assembly. Thank you.
Point of order,
Thank you,
Mr. Chair.
Justice Mendoza. Yes, what's the point of order, Senator Risa?
Mr. Chair, thank
Yes.
you. And with thanks to the indulgence of the Senate President pro tempore, I think that Justice Mendoza is raising a prejudicial question. And so my point of order would be until we agree upon and comply with the proper constitutional procedure, I would move, Mr. Chair, to suspend these hearings.
Yeah.
I so move, Mr. Chair.
There is a motion to suspend. What is the pleasure of the body?
No, I
think,
object, Mr. Chairman, because
Yeah.
I think our rules allow the discussions of amendments to the Constitution. We're talking about
Yeah.
topics such as the economic provisions, even discussion on how it will be implemented. We do this every administration, every Congress. So if that's just, the prejudicial question will be taken up each time there's an amendment proposed and filed to this committee, then this committee will cease to exist. It will have no function whatsoever. So with due respect to my dear colleague, Senator Risa Hontiveros, I object to her motion.
Yes, I second the motion of the Senate President. Clearly, we have a standing committee on constitutional amendments and are free to discuss it, particularly with such able and distinguished resource persons. Thank you.
Thank you, Senate
Yeah,
President.
let me
Senator
also
Amy.
put on record, Mr. Chairman, my
Majority Leader and
objection
Senator Bato
also.
de la Rosa for an orderly proceeding. Yes, go ahead.
I
Majority
would just like to put on record my objection as well as
Mr. Chairman.
we have already put in the records.
With your
of this
permission,
chamber.
Justice Mendoza, there are some, we must settle the point of order before we go to the discussion. With your permission, yeah.
Thank you, Mr. Chairman. As this representation already read into the records, the basis of the jurisdiction of the committee, including the subcommittee, Mr. Chairman. Thank you.
Yes, it may be, yes, Senator de la Rosa, yes.
Yeah, Mr. President, I just would like to manifest my support to our Senate President because right now, as we speak, we are not yet wearing our second hat. We still have no hat right now. So
I thought you were wearing a hat. I thought you were wearing a hat.
we have to wear our second hat later, maybe, Mr. President. Right now, there's no prejudicial issue right now.
Senator,
So,
next guy.
thank you, Mr. President.
Senator Escudero, yes.
It's Senator Bato who might need a hat, Mr. President. May I, to educate us as well, may I ask my former professor, Justice Vivi, yung pag-uusap po ba sa pagitan ni Commissioner Suarez at ni Commissioner Regalado na kailangan joint session, voting separately, kapag ka ang napagkasundoan ay bicameral, ay nasa record ng Constitutional Commission o pribadong pag-uusap po ba yun?
It's in the record, Mr. Chairman. And I can cite the record if you give me time.
If it's in the record, Mr. Chairman, I think there is good reason to proceed with it cautiously because all of these proceedings might be for naught. Because as we know, the debates in all of the laws that we pass form part of the intent of Congress. And insofar as the Constitution is concerned, the debates too would form part of the intent of the framers of the Constitution. And if that is what they intended for it to mean, then we might be treading on questionable, to say the least, waters if we proceed in this manner. baka may bagong akusasyon na naman na sinasabotahin ng personal. It's better to proceed with it cautiously and take note and take heed of the points raised by Justice Mendoza as well as the other justices and Chief Justice before we proceed, because this is already the beginning of our second half. I think that's the point of Justice Vivi.
Mr. Chairman,
Again, we don't know yet, and the committee report will be the product of this proceedings. So perhaps we can proceed with the hearing and hear out all of our resource persons. And for today, until we decide on the matter and be guided accordingly. Para naman hindi masayang yung hearing today.
Yeah.
I appeal to Senator Risa for at least for this afternoon.
Thank you, Senator Cheese.
Mr. Chair.
Senator Lauren was also raising her hand. I think she wants to speak. And then the minority leader, I think, wants to speak also. So, Senator Lauren, Senator Pro Tem.
Actually,
Yeah.
I have not utilized my time, so
Yes, but there's a point of order, and in the
correct.
rules, point of
I-
order takes precedence. Your
I
Honor.
know. Are the
So let's settle the point of order so we can go back
have
to
you
you.
settled it
Yeah.
already?
We've
or-
not. We've not.
Not yet.
We are hearing the
Okay.
arguments
Okay.
for and against, Your Honor. Yeah.
May we settle the point of order, Mr. Chair? Then I proceed with my questions for the justices. Yes.
Yes, but please,
After.
that's why. If we can settle this, then we can go back to you. Senator Minority Leader, yes.
Well, as I understand the point of order to be, it's not really a permanent suspension. It was just a temporary suspension of the committee hearing.
State PRO, Your Honor.
So that we can digest the inputs given to us. But I think the movant wants to add something. So
Back to the movement, Senator Risa.
Thank you, Mr. Chair and dear colleagues. So just to reiterate, as the minority leader said, my motion was to temporarily suspend the hearings until we answered what I believe is a prejudicial question being raised by Justice Mendoza, until we determine and comply with the proper constitutional procedure. And as part of, as the minority leader said, digesting what has been brought up so far, also through reviewing the records of the deliberations of the Constitutional Commission. But in the meantime, in response to the first objection of the Senate President and the request of Senator Cheese, and having clarified the intent of my point of order, because I feel, most of all, Mr. Chair, I feel what Justice Mendoza has raised is a prejudicial question. But for now, I submit to the objection and the ruling of the chair.
So I
For
take
today,
it
Mr.
you're not
Chair. Thank
insisting
you,
on the
Mr. Chair.
motion for today. Yeah.
I am submitting
Yours,
to
your-
the objection, Mr.
Okay.
Chair.
Thank you for graciously doing so. That allows us to proceed. And of course, we want to place it on record. Justice Mendoza's opinion is one of many. And earlier we heard a contrary opinion from Justice Ascuna, who was a member of the 1987 Constitutional Commission. So even the best lawyers, this shows the public that even the best lawyers can disagree sometimes.
Mr. Chairman.
Yes, Chief Justice David.
just to add a little on the controversy. It is just to correct the part of the statement of Justice Mendoza on what happened in the Constitutional Commission. The fact of the matter is I happen to be the chair of the Legislative Committee, and my good friend Adolf here was the vice chairman of that committee. The committee recommended a unicameral body. And at the time that the transitory provision, rather the article on amendments and revision to the Constitution and transitory provisions were taken up, it was based precisely on the assumption that what would be adopted eventually would be as recommended by our committee, which was unicameral. Unfortunately, during the plenary session on a voting as to the form of government, whether bicameral or the form of the legislature, whether bica or uni, by one single vote, the committee lost. And it was the motion of Delegate Villegas who voted that we adopt the bicameral assembly. Same thing happened in the committee, as a matter of fact. The committee actually voted for a bicameral body originally. As chair, I voted to break the tie in favor of uni. So that is exactly what happened. But you don't have to worry about it, because if you read the commentary of Justice Father Barnas, one of the members of the Constitutional Commission,
in his book, The 1987 Constitution of the Republic of the Philippines, a commentary, 2003 edition, page 1297, it is very clear that Congress may do so, propose amendments either a single body or in a joint session. If it were in a single body, each one can propose. And that was what I answered before to the question of Senator Legarda. What Congress can do in the first instance would be a simple legislation, proposing an amendment. So the Senate can do that, propose an amendment. Or, once it is approved, the proposal will go to the lower house. The lower house, in the regular process of legislation, will act on it. There may be debates. As earlier, there may be amendments. And several amendments may be proposed. On deck, for instance, is the resolution of both houses number 6 now in the lower house, authored by Congressman Salceda. It will open up the entire provisions on the national patrimony and economy. Not only 3, not only 4 in the resolution of Senator Gatchalian, which is your joint, which is actually your resolution about houses number 1. That was the first. That was filed in July of 2022, and it was submitted to the Mother Committee on Constitutional Amendments and Revision of Codes. And public hearings were had on, as earlier announced, all over the country. But we do not know yet what had been the proposal of the Mother Committee. And that is exactly the reason why I also raised in my preliminary statement whether, after this subcommittee shall have acted on this resolution number 6, the subcommittee's report will go back to the Mother Committee. And the Mother Committee to treat it simultaneously with the resolution of Senator Gatchalian. If it had not been acted upon, there are no reports. If there had been a report, we should like to find out. Now again, if there had been no report, does it mean that by treating this particular resolution, we will be abandoning resolution number 1? So that is the issue that I raised. So now, since it was, go back to the issue of BICA and UNI, I would request you to, is embodied in my position paper, and it is also in my position paper submitted to the Committee on Electoral Reforms and People's Participation of the Honorable Amy Marcos. So these are the clarifications I would like to put.
Thank you very much, Chief Justice David.